3 a.m. You're staring at your ceiling. Your naturalization certificate is in the drawer. But tonight it feels like paper instead of protection. You hear the news: deportations, raids, immigration crackdowns. And suddenly that question crawls into your mind. Can they take it back? Can they actually revoke my citizenship? I'm going to tell you something right now that might let you sleep tonight. The answer is more complicated than yes or no. But by the end of this video, you'll know exactly where you stand, what's actually protected, and what you can stop losing sleep over. Because what you're feeling right now, thousands of naturalized citizens are feeling it too. And most of what you're afraid of isn't real. Let me show you what is. Welcome to Entry Status USA. I'm here to cut through the noise, the panic, the misinformation that spreads like wildfire every time immigration hits the headlines. If you're a naturalized U.S. citizen watching this in February 2026, you're probably seeing enforcement stories everywhere. You're hearing words like crackdown, deportation wave, immigration overhaul, and if you spent years navigating the immigration system, if you remember what it felt like to be vulnerable, to wait for approvals, to worry that one mistake could cost you everything, then this current climate probably feels personal. It feels threatening, even if logically you know you're a citizen. Now, today we're going to walk through the constitutional reality of your citizenship, what denaturalization actually means, what Trump administration policies in 2026 can and cannot do to naturalized citizens, and the practical steps you should take right now, not the panic steps, the smart ones. This isn't about politics. This is about law. This is about your rights. And this is about replacing fear with facts. If that's what you need right now, you're in exactly the right place. Let me start with the foundation, because once you understand this clearly, a lot of the fear starts to crack. Your citizenship, once lawfully obtained, is a constitutional status, not an administrative one. That distinction matters more than almost anything else I'm going to tell you today. The 14th Amendment to the United States Constitution doesn't say your citizenship is granted by the President. It doesn't say it's managed by the Department of Homeland Security. It doesn't say Congress can vote it away with a simple majority. It says that if you were born or naturalized in the United States and subject to its jurisdiction, you are a citizen. Period. That's not policy. That's not regulation. That's constitutional bedrock backed by Supreme Court precedent going back over a century. When you completed your naturalization process, when you passed your civics exam, when you demonstrated English proficiency, when you met the residency requirements, when you disclosed your background honestly, when you stood in that courtroom and took the oath of allegiance, you didn't just get a certificate. You acquired a constitutional status. You became the legal equivalent of someone born in Nebraska or California or Florida. There is no asterisk next to naturalized citizenship. There is no fine print that says this expires if politics shift. There is no clause that says this can be revoked if enforcement gets aggressive. Now, I know what some of you are thinking. You're thinking about denaturalization. You've heard that word. Maybe you saw it in a headline. Maybe someone forwarded you an article with a terrifying title. Maybe you read a social media post claiming mass revocations are coming. So let's talk about what denaturalization actually is, because the reality is far more narrow and far more specific than the fear. Denaturalization is a legal process, emphasis on process, that allows the federal government to revoke citizenship in extremely limited circumstances. And I want to be very clear about what those circumstances are. The government must prove in federal court that a person obtained citizenship through fraud or by willfully concealing material facts during the naturalization process. Notice what that requires. Fraud, willful concealment, material facts, proof, federal court. This is not an administrative action. This is not something that happens because you criticize the government. This is not something that happens because you traveled to the wrong country. This is not something that happens because your politics changed, or because you attended a protest, or because you posted something controversial online. Denaturalization cases are about whether the original naturalization was legally valid. Did you lie on your N-400 application about serious criminal history that would have disqualified you? Did you use a false identity to obtain citizenship? Did you conceal involvement in persecution, genocide, or terrorism? Did you fraudulently claim military service? Did you deliberately omit information that was legally material to your eligibility? Those are the kinds of situations we're talking about. And even in those cases, even when the government believes fraud occurred, they cannot just administratively cancel your citizenship. They must file a civil lawsuit. You have the right to an attorney. You have the right to present evidence. There is discovery. There are evidentiary hearings. There is a judge. The burden of proof is on the government, and it's a high burden. Historically, denaturalization cases are rare. They are expensive. They are time-consuming. They often take years to resolve. The government has to dedicate significant resources to proving fraud in each individual case. This is not a tool that can be wielded broadly. This is not something that can be applied to thousands of people through an executive order. The legal standard has not changed in 2026. There has been no new legislation lowering the burden of proof. There has been no Supreme Court decision weakening protections for naturalized citizens. Even if an administration wanted to pursue denaturalization more aggressively in cases where actual fraud occurred, they would still be bound by the same constitutional due process requirements that have existed for decades. So when you hear phrases like revoking citizenship or stripping nationality, understand what that actually refers to in legal terms. It refers to a court-driven process tied to fraud at the time of naturalization. It does not refer to a political mechanism that can be activated against law-abiding naturalized Americans because immigration policy shifted. Now, if all of that is true, if naturalized citizenship is constitutionally protected and denaturalization is narrow and rare, why does it feel so unstable right now in February 2026? Why are so many naturalized citizens lying awake at night worrying? The answer is enforcement visibility. Let me explain what I mean by that. The current administration has significantly increased immigration enforcement operations. ICE activity is more frequent and more publicly reported. Detention numbers are higher. Border enforcement is stricter. Deportation flights are happening regularly, and they're being covered extensively in the media. Workplace enforcement actions are making headlines, and every single one of those stories gets amplified on social media, often without context, often without clarification about who is actually affected. That creates an atmosphere. It creates a feeling that the entire immigration landscape is unstable, that anything could happen to anyone. But here's the critical distinction that gets lost in that atmosphere. Immigration enforcement actions target immigration violations, undocumented presence, visa overstays, final removal orders, criminal convictions that triggered deportability, people who are in the United States without lawful status or whose lawful status has been terminated. Naturalized citizens do not have an immigration status. You're not here on a visa. You're not maintaining a green card. You don't have conditions to fulfill. You are not in the category of people who are subject to removal proceedings. Your legal relationship with the United States is fundamentally different. But I understand why the distinction gets blurred. Immigration debates are often framed in sweeping language: crackdown on immigrants, tough new deportation push, immigration overhaul. Those phrases collapse multiple legal categories into a single emotional concept. A tourist on an expired visa is not the same as a green card holder. A green card holder is not the same as a naturalized citizen. Enforcement targeting unlawful presence does not legally extend to people who have completed naturalization. But when the rhetoric is intense, when the headlines are constant, when enforcement footage is everywhere, people who spent years in vulnerable immigration categories can instinctively feel like that vulnerability has returned. Emotionally, I absolutely understand why that happens. Legally, it hasn't. Let me address 3 specific claims that are circulating right now because misinformation spreads fastest during moments of anxiety. The first claim is that mass denaturalization is coming, that the government is preparing to strip citizenship from huge numbers of naturalized Americans, possibly targeting specific nationalities or religious groups. There is no legal mechanism for mass denaturalization. None. Denaturalization requires individualized federal court proceedings. Each case must be proven separately. There is no administrative process that allows the government to denaturalize people in bulk. There is no executive order that can override that requirement. There is no legislation currently enacted that changes this standard. The second claim is that certain groups are being targeted for citizenship revocation based on their country of origin or religion. While it's true that immigration enforcement priorities can focus on particular regions for security vetting or visa scrutiny, denaturalization itself must be based on fraud or material misrepresentation proven in court. Targeting citizenship revocation based on race, national origin, or religion would be blatantly unconstitutional. It would trigger immediate legal challenges, and those challenges would almost certainly succeed because that kind of targeting violates equal protection principles that are deeply embedded in constitutional law. The third claim is that naturalized citizens need to take immediate dramatic action to protect themselves, renounce other citizenships right away, file special protective paperwork, pay for services that promise to secure your status, register with organizations that claim they can defend your citizenship. None of that is necessary. Your citizenship is already protected by the Constitution. There is no additional filing that makes it more secure. There is no form you missed. There is no registration requirement you overlooked. And I want to be very direct about this because it makes me genuinely angry. Fear-based businesses emerge during times like this. People see anxiety and they see profit. Be extremely cautious of anyone who asks you to pay money to secure something that is already legally secure. A legitimate immigration attorney will tell you clearly if you need their help or if you don't. They will not invent emergencies that don't exist. So, let's talk about what you should actually do. Not because your citizenship is in danger, but because being prepared and informed is always smarter than being reactive. First, safeguard your documentation. Keep your naturalization certificate in a secure location. Make copies, physical and digital. Store them somewhere safe, somewhere accessible if you need them quickly. This isn't about expecting your citizenship to be questioned randomly. This is about practical preparedness. You might need to prove citizenship when applying for a passport, sponsoring a family member, or replacing lost documents. Having organized records eliminates stress in those situations. Second, understand your rights clearly. As a U.S. citizen, you have full constitutional protections. You cannot be deported. You can travel on a U.S. passport without restriction. You can vote in federal, state, and local elections. You can run for office. You can petition for family members. You have the right to due process in every legal context. These are not theoretical rights. These are enforceable protections. Sometimes simply reviewing what citizenship actually grants you can restore a sense of stability that headlines temporarily disrupted. Third, if you have family members who are lawful permanent residents and eligible for naturalization, this is a meaningful moment to encourage them to apply. I'm not saying this to create urgency where there isn't any. I'm saying it because permanent residence, while strong, is not the same as citizenship. Green card holders can be placed into removal proceedings under certain circumstances. They must maintain continuous residence. They can lose status if they commit certain crimes or abandon residency. They are still operating within the immigration system. Naturalization removes you from that system entirely. It provides finality. The naturalization process itself hasn't fundamentally changed in 2026. It still requires meeting residency requirements, passing the civics and English exams, and demonstrating good moral character. But if someone in your family qualifies, pursuing citizenship provides long-term security that is especially valuable in a high enforcement environment. Now, let's talk about more complicated family situations because this is often where real anxiety lives. If you have undocumented relatives, I'm not going to sugarcoat the current reality. Enforcement is active. Deportations are happening. Undocumented status carries significant vulnerability right now, more than it has in several years. Hoping that enforcement will quiet down is not a strategy. That doesn't mean panic. It means consultation. There may be relief options that haven't been explored. Adjustment of status through family relationships, asylum claims, humanitarian protections, waivers for unlawful presence, cancellation of removal. But those options are intensely case-specific, and they require evaluation by a licensed immigration attorney. Guessing based on internet forums or advice from non-lawyers is dangerous, especially in this climate. If you're sponsoring a relative from abroad through family-based immigration, understand that while family immigration remains fully legal, processing times may lengthen, scrutiny may increase, and policy changes could affect certain preference categories or country caps. Delaying unnecessarily can sometimes mean facing stricter standards down the road. And if you travel internationally as a naturalized citizen, always travel on your U.S. passport. The United States recognizes dual citizenship, but not all countries do. If you plan to visit your country of origin, be aware of that country's laws regarding dual nationality, taxation, or military service obligations. None of those issues affect your U.S. citizenship, but they are practical realities worth understanding before you go. Do you need an immigration attorney right now? For most naturalized citizens with straightforward histories, the answer is no. If you obtained citizenship lawfully, answered your application honestly, and haven't been contacted by any government agency questioning your naturalization, there is no preventive filing you need to make. Citizenship doesn't require maintenance. It doesn't renew. It doesn't need defensive paperwork. However, if you're sponsoring family and the case involves complexity like prior deportations, criminal issues, or waiver applications, get professional help. If you have undocumented family members trying to assess options, that absolutely requires individualized legal evaluation. And if you ever receive formal communication from USCIS, the Department of Justice, or any federal agency questioning your past immigration applications, that is the moment to seek counsel immediately. Don't wait. Don't try to handle it yourself. When I say attorney, I mean a licensed immigration lawyer, someone admitted to practice law, ideally with a focus on immigration and preferably a member of the American Immigration Lawyers Association. Be cautious of anyone who guarantees results. Be cautious of large upfront cash payments without written agreements. Be cautious of notarios or immigration consultants who present themselves as attorneys when they're not licensed to practice law. Immigration fraud thrives during periods of fear because fear creates opportunity. A real attorney will evaluate your case honestly, explain risks clearly, and never promise outcomes they can't control. Let me shift to something that doesn't appear in statutes but is absolutely real: emotional residue. Many naturalized citizens carry years, sometimes decades, of immigration-related stress. You might remember what it felt like to wait for work permit approvals, to obsessively check case statuses online, to worry about missing a USCIS notice, to fear that a single error could destroy everything you built. That psychological imprint doesn't vanish the moment you receive your naturalization certificate. So when enforcement headlines surge, even if you intellectually understand that your citizenship is secure, your body might react differently. You might feel a flash of the old fear. You might question something that's legally settled. That reaction doesn't mean you're misunderstanding the law. It means you lived through real vulnerability for a long time, and your nervous system remembers. Give yourself credit for that journey. You navigated one of the most complex legal systems in the world. You met every requirement. You earned citizenship lawfully. The anxiety you felt during your immigration process was completely rational. But your legal status has changed. You are no longer provisional. You are no longer conditional. You are no longer waiting for approval. If the current political climate reactivates old fears despite knowing the legal facts, lean into community. Talk to other naturalized citizens who share similar experiences. Connect with immigrant advocacy organizations that provide accurate information. And if the stress feels genuinely overwhelming, there is no weakness in seeking mental health support to process it. Security is both a legal condition and a psychological one, and both matter. As we look at the bigger picture in February 2026, it's crucial to separate two forces that often get mixed together: political climate and constitutional structure. Political climate shifts quickly. Enforcement priorities intensify. Rhetoric sharpens. Media coverage amplifies every action. But constitutional structure moves slowly, deliberately, with high barriers to change. Citizenship falls into that structural category. It is anchored in the 14th Amendment. It is reinforced by over a century of Supreme Court precedent. That foundation does not shift with each election cycle. So when you hear sweeping language about immigration crackdowns, remember that those policies operate within specific legal categories: undocumented status, visa violations, removal orders, asylum eligibility. Citizenship is an entirely different category. If you naturalized lawfully and honestly, there is no hidden mechanism waiting to undo it. There is no executive shortcut. There is no quiet administrative sweep. There is no 2026 statute that rewrote denaturalization rules. The legal standard remains fraud or willful concealment proven in federal court with full due process. Here's what we know with absolute clarity in February 2026. Immigration enforcement is visible and active. Deportations of individuals without lawful status are occurring regularly. Border policies have tightened, detention capacity has expanded, political debates around asylum, work visas, and family immigration continue to be intense. But none of those developments, none of them, alter the constitutional permanence of lawfully obtained naturalized citizenship. If you answered your N-400 truthfully, disclosed what you were required to disclose, met all eligibility requirements, and took the oath, your citizenship is secure under the Constitution. That is not optimism. That is not wishful thinking. That is legal fact. The path forward is not panic. It's awareness. Stay informed through reliable sources. USCIS official communications, the State Department, reputable legal organizations like the American Immigration Lawyers Association, licensed immigration attorneys, not social media threads, not forwarded messages, not fear-based websites trying to sell you protection you don't need. Keep your documents organized. Encourage eligible family members to naturalize if they qualify. Seek professional legal advice when situations are genuinely complex. And most importantly, allow yourself to live in the stability you earned. You have the right to vote. You have the right to travel on a U.S. passport. You have the right to petition for family members. You have the right to live in this country without fear of deportation. Those rights are not symbolic. They are enforceable constitutional protections, and understanding them fully is one of the most powerful responses to a noisy, anxious political moment. If this video helped you separate legal reality from fear, if it gave you clarity you needed, hit that subscribe button right now. Entry Status USA is committed to fact-based immigration information that cuts through misinformation and focuses on what the law actually says. Share this video with someone who might be quietly worried but hasn't had access to accurate information. And if there's a specific immigration topic you want us to cover next, a claim you've heard, a situation you're navigating, leave it in the comments below. Your questions help us create content that addresses real concerns in our community. Thank you for being here. Thank you for trusting us with these important questions. And thank you for being part of a space where accurate information is treated as protection, not politics. You worked hard for your citizenship. You earned it, and it's not going anywhere. Remember that. I'll see you in the next one.